Good morning, everybody in Europe. Good afternoon, everybody in China. Welcome to EUSME Central webinar series, and today on topic on how to operate lawfully in China, a legal update. It is always a challenge to open a company or conduct a business here in China, but it is sometimes more challenging to operate the business and keep continuing business activities. And how to do it lawfully, it requires to be regularly updated. Today we have a very experienced speaker, Mr. Florian Kessler, who I will introduce a little bit later. But firstly, some technical topics. You are very welcome to ask us any questions related either to the operating lawfully in China or to any other topic which we might reply a little bit later. And for this, you have specific window in your panel. It is titled questions, so please type us any question, and me, our speaker, or our assistant here will help you to answer. I believe that many of you who are listening to us are our old friends and regular participants to our EUSME Centre webinar series. However, for those who are new to us, let me shortly introduce EUSME Centre and what services we provide. So the centre is located in Beijing, and it is project funded by the European Union, and our main purpose is to assist small and medium-sized companies from European Union to export to China, export their products, goods, services and technology, or if they wish to establish and develop their commercial activities. We provide our services via the confidential information and advice and practical support services. Some of those services is Ask the Expert. On our website there is a specific function called Ask the Expert, and you may ask questions related to the business development, standards and conformity, legal or tax or human resources. We as well provide face-to-face consultations. We have more than 100 publications, reports, guidelines and case studies related to the sectors and the subsectors, conditions in market, how to establish a company here, how to calculate tax and many others. We conduct trainings in Europe, in China, same in face-to-face or webinars like this one. We organize matchmaking events. We have few very useful databases like exhibition database and service providers database, and we as well run law database. If it happens and you are in Beijing for a business trip, you are very welcome to visit our center and stay with us because we provide hot desking services. You can use internet, phone and our meeting rooms. So now to our today's topic, and first of all to our today's speaker, Mr. Florian Kessler. Mr. Kessler is heading the Beijing office of the German law firm Wilfing Zeuner Rechel, and he has very long experience and expertise in providing legal advice and business development advice in the Chinese market. He served more than 7 years as a general manager of the service section at the German Chamber of Commerce in North China. He is a frequent publisher and a speaker on Chinese law in China and in Europe as well. He is a visiting professor at China University of Political Science, and he has been also appointed arbitrator at the China International Economic and Trade Arbitration Commission. So you see that his experience is really long-term, and I would pass the floor to him to introduce the topic and our agenda.
Yeah, also a warm welcome from my side here in Beijing. Right now, Beijing is preparing for the big APEC conference, which will start next week here. And Chinese government has enforced severe traffic restrictions. Schools are closed. Companies have been asked to shut down their operations. And even all the companies have been asked to send their staff members home. I don't know if the USME Center is operating during APEC conference or not, but...
Well, we are operating.
Okay,
yeah,
okay.
Same as you probably.
But anyway, so the goal, of course, is to present to the world leaders, Obama, Putin, a blue sky and empty streets here in Beijing. Let's see if they can do it. Anyway, today the pollution is quite heavy here in Beijing. But anyway, so let's go right into the topic. Today I brought you a small choice of topics: compliance, company law, labor law, trademark law, to keep you updated with the recent legal developments here in China. But please consider those topics just as a suggestion from my side. If you have any other legal question, please feel free to ask me. So this is just, a suggestion from my side. Before I start with the first topic, I would like to make two general remarks on the legal situation here in China. First, the Chinese Communist Party last week held its annual meeting here in Beijing, and some of the Chinese government leaders, they said that they would like to further enhance the rule of law principle here in China. Ladies and gentlemen, please be careful or don't be misled by those statements, because the full term is socialist rule of law with Chinese characteristics. So if you see the full term of the Chinese leaders, then you can see that Chinese leaders, they maybe understand the term rule of law different from our Western perspective, right? And of course, it can't be the same, because still in China, we don't have any balance of powers, we don't have any control of powers. The judges are not independent, they have to report to the Communist Party, and I'm sure that this situation will not change in the near future. Yeah. So this is just one general remark. Another remark is, Chinese government is very aware that they right now have to offer a big market, So for Chinese government, there is no need to liberalize the foreign investment environment, because they know foreign companies will come here anyway. They're even dependent on the Chinese market. So just, want to make you aware with the situation, the Chinese government, why should they see any need to further liberalize, the foreign investment framework? Because companies, according to their idea, companies will come here anyway. So now let's start with the first topic, compliance, and I would like to, put a focus on the prevention of corruption. I think most of you have learned from the newspapers that Chinese prosecutors, Chinese authorities have been investigating against the British pharma company GlaxoSmithKline, GSK, and recently GSK has been fined, with more than 380 million euros, and more important, the Chinese management of the Chinese subsidiary has been sentenced to prison. Yeah. So what you can see from this is that also China is not only hitting hard against corruption, but they will also focus foreign companies, and they are not hesitating anymore, to hit hard also against foreigners operating here in China. But, when talking about the GSK case, I would like to highlight one aspect that has not been well noticed by most of the public. There haven't only been investigations here in China, but also the UK Serious Fraud Office initiated investigations in the UK. And moreover, also the US Department of Justice, they initiated proceedings in the US. So why is that so? Because in the international, corruption law, there is one rule that says the law of your home country always has so-called extraterritorial effect. That means that even if you're operating in China or the bribery action is taking place in China, the law of your home country will apply simultaneously. So you always have to consider that, you can see on this slide here, that when you're doing business in China, you not only have to comply with the Chinese law, but you also have to comply with the law of your home country in China. Yeah. So one of your employees is taking bribery actions in your subsidiary here in China. You know, you're not only subject to criminal prosecution in China, but you also may be subject to criminal prosecution in your home country. That means, in other words, what happens in China does not stay in China, right? So I think this principle, many companies are not aware of this principle, that there could be simultaneous investigations in several countries.
Florian, let me interrupt you at this moment, and we will launch our first poll. And because, as you said, not many companies put the compliance and the anti-bribery measures on top of their agenda. So we would like to know our participants' opinion, experience about this topic. So I'm launching our first poll, and the question is your company enforcing anti-bribery measures in the China business? And answers are very straightforward: yes, no, we are planning, discussing to implement. So please send your votes, and we will comment after it. So few more seconds. Fine. So I'm closing voting now, and let me share results with you. Now, half of you voted for an option yes, that your company is enforcing anti-bribery measures in the China. 23% no, not, and 27% planning. So I think it's our webinar is very well scheduled to show the importance of these measures and to have the compliance policy focused on this. What do you think, Florian?
Yeah, I think that shows that that more and more companies are aware of that issue here in China, and that there is a specific need here in China to deal with that topic somehow, right? So yeah. Anyway, so let's move further. I would just like to give you an example. You know, I just said before the poll that that you always have to also follow the rules of the law of your home country, right? So now, when we talk about value of gifts, I think this question appears quite often. You know, companies are asking, you know, what are there any thresholds for values of gifts? And now, first we look if there are some thresholds in China. As you can see from this slide, indeed, in China there are clear thresholds. In Chinese regulation, it is suggested only to start criminal proceedings if the value of the gift exceeds 10,000 RMB, which is equivalent maybe to more than 1,000 euro, right? So for 1,000 euro, I mean, you can invite your customers for luxury dinner or for a KTV show in the evening, whatsoever. So I think this is quite, it's not a very strict rule, but you can see in China there are quite, there are explicit thresholds stipulated here in the law. So, but now, for example, if you look to European laws, you will see that in most of the European laws, you don't have any explicit or clear thresholds regulated in the laws. But however, you know, there are some other sources that might provide further guidance for you, you know, what approximately the threshold might be in your country. I will give you an example from Germany. For example, in Germany, there's lots of scientific literature. They deal with that topic, and they're, you know, talking about 25 up to 50 euro. And then if you have a look at the German tax law, you will see that only gifts up to 35 euro are deductible, you know, from corporate income tax perspective. And then there's also like a common understanding, you know, between the multinational companies in Germany. And they are also only talking about maybe 20 up to 50 euro. So although in Germany it's not explicitly stated in the law, you might have other sources to get further guidance. So, now come back to my takeaway, you know. because the thresholds in Germany are so low, that means German companies operating in China, they have to comply with those, lower thresholds even in their China business here. So they cannot, I will go back, they cannot, make use of the full range of the Chinese regulations, but they have to follow the strict rules of their home country, even in China. So, this just to make it more clear and to give you an example. Yeah. Okay, let's go on. So now the question is, what can you do as a company to prevent the risk that your management here might be prosecuted, or even, the management of your home country might be prosecuted or criminally prosecuted? First is prevention, second is disclosure, third is sanctions. So you have to do, in the critical cases, you have to show to the criminal prosecutors that you minimized the corruption risk in your company. So how can you do it? First, of course, you have to nominate a person in your company who is in charge of the topic compliance. This doesn't necessarily have to be a new staff member. This task could also be taken over by existing staff, but at least there should be someone in charge of that topic in your company. Secondly, you should draft a so-called code of conduct. That means like a handbook that tells your employees what is allowed, what is not allowed, in terms of gifts. And ideally, you will also stipulate exact thresholds in this code of conduct. My suggestion would be to use the so-called traffic light principle. So in your code of conduct, you will write down, what is green light, so what are social adequate benefits, for example, a ball pen with a company logo on it, or what is yellow phase, where you have to ask for approval from your boss, or what is red phase, what is prohibited in general, like cash benefits, sexual benefits, and so on. So this is, just some brief guidance for you. I don't want to go more into detail. You can look at the slides for further aspects. And then I would like to draw your attention also to the topic of compliance controls. I mean, of course, many employees, they might be reluctant to report compliance offenses or bribery acts to their boss because maybe they are afraid that it will affect their career negatively. So you have to make sure that your employees can report acts of bribery on an anonymous basis. So many companies, they deal with external persons, like external lawyers and so on, right? So, yeah.
So, Rian, two questions to this topic. First one is, you were speaking about companies, employees, and what is the liability inside the company. How does it affect the agents, and how far are companies so liable for bribery actions of their agents and the distributors? So not those belonging to the company, but external third parties.
I think that's a very relevant and good question, because I think many of you might be operating with agents or distributors here in China. So the question is, how can the management in your headquarters be made responsible or liable for bribery acts done by agents or distributors? You have to distinguish. Agents usually, they don't act in their own name. Agents usually will act in the foreign company's name. So usually they are acting in the name of the foreign company. So their actions, usually or generally speaking, foreign companies are liable for acts of their agents, because agents are not acting in their own name, but rather acting in the name of the foreign company. The situation is different with distributors, because distributors usually will buy products from the foreign companies in their own name, and then they will resell it in their own name and not sell it in the name of the foreign headquarter, right? So generally speaking, foreign companies cannot be made be liable for actions of their distributors. Of course, in fact, it's more complex, but I just would like to give some first advice here.
Yeah,
right?
that's very useful. Another question is about governmental officials, because We know that in business negotiation, very often companies here negotiate not only with the third parties, companies, agents, distributors, as just mentioned, but very often as well with the governmental officials. So bribes offered to the governmental officials are normally subject to higher punishment than bribes offered to bribe companies. So who are those? How to define, how to differentiate who is governmental official and who is not?
I think this is a very sensitive topic here in China because practically speaking, everyone could be a government official here in China. You know, there is a specific regulation on that topic, so that says that every employee of state-owned enterprises could be considered as government official. Also people working in the military or peoples of the Nationals Congress. So the term government official here in China is very broad. So even employees of private-owned companies could be government officials, for example, if they are dispatched by state-owned enterprises, you know. So this is a very sensitive topic. And indeed, you know, right now government officials, they're, you know, Xi Jinping, the China president, he's even launched a manhunt right now. They call it a fox hunt, you know. Now they're going for government officials who took their money, went abroad, you know. So I think it's a very sensitive topic. And so if anyone is interested in that regulation who could be considered government official in China, please contact me.
Yeah. Thank you.
Okay, of course, and then maybe just to conclude this topic, just want to say, of course, if you discovered a case of corruption in your company or bribery, you have to take appropriate reactions. That means any person that has been involved in that bribery case maybe should be fired or the contract has to be terminated, right? So this is maybe just to give you some, you know, first general advice. Okay, so this would be my first topic, prevention of corruption. Now let's move to the second topic, which is the new company law here in China. So the company law recently has been revised, speaking in March 2014, and many rules in the Chinese company law have been erupted. And the Chinese Ministry of Commerce made clear this summer that those amendments also apply to foreign invested enterprises. I think this is very important to be aware of. So now, what are the concrete changes in the company law? You know, before there were certain time schedules or time limits. Within those time limits, you had to inject your registered capital here in China. For example, a foreign invested enterprise had to inject its registered capital within 2 years after issuance of business license. Now, this requirement has been abolished. Now you can define, if you want to establish a company here in China, you can define by yourself the time frame within you would like to inject your registered capital. Second, in the Chinese company law, there were certain stipulations about minimum registered capital. Also, those minimum registered capital requirements have been eliminated now. But be careful, you know, there might be some specific industry laws, you know, maybe for the logistic industries, and those specific industry laws might still require a minimum registered capital, and those regulations will continue to be valid and will continue to apply. But the general rule is that there is no minimum requirement on registered capital. Also, there has been a fixed ratio on the percentage of cash contribution in the past. So, like 30% of your registered capital had to be injected in cash, and only 70% could be injected as contribution in kind. Now let's move on to the last point, capital verification. You know, usually a foreign invested enterprise, they had to provide proof to the Chinese authorities that they had duly injected their registered capital. And the way to do it was to provide a so-called capital verification report to the Chinese authorities that had to be issued by a Chinese or a licensed auditor in China. Now, this requirement also has been abolished.
Yeah. I have a question because probably every company, or not probably, definitely every company invested already here in China knows the trouble between total investment and registered capital, the ratio, like 30% for the loan, 70% for the registered capital. Is there any change brought by the new company law in this aspect?
Right. I think this is a very important question because although many of the former requirements have been abolished, the ratio between, foreign debt financing and registered capital is still valid. This hasn't been changed, So in practice, it's like this. The difference between the total investment and registered capital of a foreign invested enterprise represents the foreign debt quota. So to some extent, you could finance your Chinese operation by taking foreign debts, maybe a shareholder loan or something else. So this ratio between registered capital and foreign debt still has to be followed, right? Mm-hmm. So I just maybe just have a quick follow-up on the last point I just mentioned, the capital verification report. It has been abolished now, but still you need to show or demonstrate proof to the Chinese authorities that you have injected the registered capital. For example, you have to show to the Chinese authorities maybe a bank receipt, for example, of the Bank of China. Then they will issue a statement that they received the registered capital on an account here in China. So this is how you have to do it in the future, And of course, the China subsidiary has to issue a so-called investment certificate to its shareholders, and the whole set of documents you will provide to the Chinese authorities.
Yeah, one question to company law or amendment to the company law. It's clear that it applies, all these new rules on the registered capital applies for the companies after the March 1st. We wish to invest here. Can some of those clauses apply as well for the companies who are already settled here, who are registered before March 1st?
Okay, so generally speaking, the new law only applies to companies who are planning to establish a company here after March 2014. But the new law also provides that companies that are already here, that already have been approved in the past, could also be entitled to the new benefits of the new company law if they officially apply for it. So companies already operating in China might also consider maybe to reduce their registered capital or to make changes to the time frame within they have to inject the registered capital. They can do it if they apply to the Chinese authorities. But of course, since the new law just had recently been entering into force, there are no practical experience how Chinese authorities will handle that issue.
Yeah. So they will probably look for some guidance from the higher levels, and it will need some time.
Yeah, that's true.
Then the practice is established.
Okay, so now let's go on. I think, from my legal practice, I think labor law is quite a hot topic, but I think you want to launch some new question or poll?
Exactly. To attract the attention and to find out the experience of our participants about the labor law. So let me launch our second poll and give some break to Florian. So our second poll is related to labor law, and we would like to know your opinion on what do you think, whether the Chinese employees are well aware of their labor rights. And answers are simple: yes, no, and to some extent. So, well, I mean, I see coming your votes, and I'm very curious about the comment from the Florian, because we are quite a long time here in China, and I think we will have a little bit different opinion than you. Okay, so I'm closing the polls and sharing results with you. So 24% of you thinks that yes, nowadays most of the employees are well informed about their rights. 18% of you thinks no, and 59% thinks to some extent, but that the knowledge about the labor rights is increasing. Well,
okay, yeah.
Florian, what do you?
That's true. For me, this result is quite surprising because, you know, from my legal everyday practice, I can see a big part, you know, of the inquiries I get from German company or from foreign companies are related to Chinese labor law. When I started business more than 10 years ago, I could see that most of the Chinese employees, they didn't know, you know, about labor law at all. It was not a topic here. So it was quite employer friendly. And I think this situation has changed dramatically. I can see in my legal practice that recently most of the Chinese employees, they're pretty much aware of their rights, you know, and they know when can they ask for open-ended contract, open-ended labor, they know when they can ask for compensation. So I think they have been quite smart because also Chinese government, they have launched many labor hotlines. You know, people know now there are labor hotlines and they will get quick advice, you know, by government officials recently. So it turned to the whole opposite, you know, from my perception. Now the labor law is more employee friendly. You know, as I'm just speaking as a German, I could even say it's more stricter than in Germany right now. So it's almost impossible to terminate a contract with a Chinese employee unilaterally. So I think that's a big headache, you know, from my perception. So I'm quite surprised about the result. But anyway, so maybe my idea is just to share with you just some recent important interpretations that have been issued by the Supreme People's Court and the Beijing courts here. You know, of course, I cannot cover all the courts here, but you know, yeah.
And it's quite important as you as a companies or employers, you are well aware about it, because for sure the employees, they are already aware of it. So be prepared.
Yes. So I can see they're aware, and they're even making, you know, use of the loopholes. They even know the loopholes and know where where they can make the employer angry. So there are recently some interpretations by China courts. I just want to give you just a very brief summary. First, the courts have been providing some explanation about what is a labor relationship and what is a service relationship. So I think maybe some of you might consider to hire maybe a retired government official, right? Maybe you want to involve them into government relations or lobbying. So you always have to take or consider, you know, if you hire retired people here in China, that you're not allowed to conclude labor contracts here with retired people. You have to conclude a so-called service relationship with them. The risk you have here is that because it's not a labor contract, you're not able to pay into statutory social security system. That means my advice would be to take care of commercial insurance. So as an employer, you cannot be liable, you cannot be liable for example, work-related accidents caused by the retired person, you know. So you want to make sure as an employer that you're not being liable for acts of the retired person. So please make sure that you buy appropriate commercial insurance. Also, this is a hot topic, so in some cases the employer is obliged to pay to the employee so-called double salary. The most important circumstance where that could happen is that you forget to conclude a written labor contract, and if I say written, I mean in Chinese language, with one of your employees. If you forget to conclude a written labor contract within 1 month after the person starts to work at your company, then you have to pay a double salary for each month the person has no written labor contract, and this could go up until 11 months in total. That could be expensive, right? So, I mean, second circumstance is, I mean, that happens a lot in practice. Maybe you first have a written labor contract. It says you have a fixed term contract of 2 years, and there is no automatic extension clause in the labor contract. And then it expires, and you forget to extend the contract, but the employee will still work at your office, right? I had many cases like this, and then also for each month the person has no written labor contract, you have to pay double salary to the employee. Could be expensive as well. Yeah. Next situation is that you as an employer are obliged to conclude an open-ended labor contract with the employee. I will come back to that later, you know, in what kind of cases you are obliged to offer an open-ended labor contract. But if you forget to do this, also you have to pay the employee for every month he doesn't have a open-ended labor contract, you have to pay him double salary. So my advice is, you know, you really need to install or implement internal contract management procedures, you know, for onboarding. That means you have to make sure people get their written labor contract within 1 month. And then of course you need some table where you can clearly see what kinds of contracts are going to expire in the near future, so you don't forget to extend those contracts. So you need an ongoing screening, you know. So make sure you have a well-established contract management here in your subsidiary. Otherwise, it could be expensive for you.
Yeah, it's very, very useful advice. And as well, I would add that make sure that you have your safe with the labor contracts locked well, because it may happen that you conclude the contract at the beginning, but when you need it, you will not be able to find it. And this point, I have a question, Florian. You mentioned several times double salary payment. What does it exactly mean? Is it a full salary? Does it bonuses included into it, or is there any cap to that?
No, unfortunately, there's no cap to that. Full salary in this case means full salary. So if the basic salary of the employee is like 30,000 RMB a month, then you have to pay him 60,000 RMB. So there's no cap on that, you know. In some cases, but you're right, in some cases in Chinese labor law, there are caps. And maybe I will come back to this later, but, you know, since the time is limited, I will not elaborate on that today. Yeah. So let's go on. So in some cases, even if you forgot to conclude a written labor contract with your employee, you don't have to pay double salary, you know. So I just want to mention, how can you avoid, you know, to have like double salary in case you don't have a written labor contract? First is, maybe the employee will agree to backdate the labor contract. You can ask the employee, oh, do you agree we backdate it to your first working day, you know? And in case he agrees, the Beijing courts, they say, okay, then you don't have to pay double salary. But usually, I mean, it depends, you know. If the employee likes the work at your company, of course, you will agree. But in some cases, I experienced employees, they just don't agree. Second is, you might, you know, stipulate in your sample labor contract an automatic extension clause. So it will be the labor contract after expiration of the fixed term, it will be extended automatically. You know, if you have such kind of clause in your labor contract, you don't have to pay double salary, you know, even if you don't conclude a separate contract after expiration of the first contract. Third, in some cases or in some circumstances, the labor contract will be extended automatically by law. So this applies, for example, in the case of pregnancy. Maybe if a female worker, she gets pregnant. In those cases, the labor contract will be extended automatically until the end of the so-called nursing period. So you don't have, in those cases, you don't have, you know, to conclude a separate labor contract. It will be extended automatically. And then finally, legal representative, you know, you can see the last point on the slide here, legal representative, they are never entitled to double salary. And also HR personnel, if they are in charge of labor contract management. So I just would like, due to time restrictions, skip the next slide and, just come back to the topic I mentioned before. In which cases Chinese employees are entitled to an open-ended labor contract. And you might know this from the law of your home country, could be the same. In China, employees are entitled to an open-ended labor contract after, the expiration of the second fixed-term contract. So you have a first contract and then you have a second fixed-term contract, and after expiration, the employee automatically is entitled to an open-ended contract. So the employer cannot decide, to conclude a new fixed-term contract unilaterally, and yeah. So also you need to monitor, the amount of fixed-term contracts you're concluding with your employees, right? So this is just my takeaway, would be my last takeaway for the field of labor law.
Yeah. I can see we have received quite a few questions about the labor law, but if you agree, Florian, I would address them at the end of the Q&A session.
No problem, yeah. So I think then we will postpone those questions to the Q&A session, and I would also like to skip maybe the last slide, or just say, maybe some words to the last slide, years of service. Of course, you might think, or you might consider it as a smart solution. If I am only restricted to 2 fixed-term labor contracts, you might consider maybe, if you have 2 companies here in China, you might terminate the contract, with the first company and then conclude a labor contract with a second company. But still, it's not possible, to circumvent the general rule. So I think Chinese courts are aware of those circumventions possibilities, and they will not allow for it. So now let's conclude my brief update here with the last topic, the trademark law. Recently, China has issued a new trademark law and has entered into force in May this year, and I just want to briefly introduce to you the major changes. So first, I think a positive aspect about the new trademark law is that for the first time, the China Trademark Office, they provide for time limits. In the past, you never knew how long it took to examine an application, trademark application here in China. Could take up to 2 years or even longer. In practice, I think the average was like 18 to 20 months. So it's quite long. So I think it's very positive now that the Trademark Office, they provide for time limits. Just give you an example, if you look at the table here, Trademark Office now says that they will review applications within a time frame of 9 months. So I think this is quite a positive aspect about the new trademark law. Maybe a more critical topic. I think you might be aware of the situation that there are many Chinese companies, who are looking for interesting foreign trademarks, right? So they will look, there may be interesting trademark in Spain or Italy, and if they like the trademark, they will register it in their own name here in China, in bad faith, of course, So maybe in the hope to sell it to the foreign company, later, or even, sell their own goods under in the name of the foreign trademark. This happens quite a lot. So I think this is quite a common topic you might also have been experiencing here. But now, if you have such kind of case here in China in the past, you could launch an opposition procedure. If you see that your trademark here in China is registered by a Chinese company, then you could launch an opposition, and if this opposition was declined by the Chinese Trademark Office, you could further appeal the decision of the Trademark Office. Now, this appealing procedure has been abolished. So if the Chinese Trademark Office, declines your opposition, then it's basically over, and the trademark, registered in bad faith first will be registered in China, and then you have to wait until it's registered, and then you might maybe launch some other procedures. But, you know, I'd say this is sort of a negative aspect of the new trademark law, that they shorten this appealing procedure here. Okay.
Just a short interruption. You had the interesting slides about examination period, and generally the examination period are shortened. Does it mean that it is a real obligation now for the trademark office to keep these shortened periods, or is it just something like internal guidelines for the authorities?
I mean, the new trademark law just has been entering into force. So, but from the first feedback we get from our clients, you know, we can see that the trademark office is really taking those shortened time frames very seriously. We also learned that, and we heard that the Chinese trademark office, they hired, you know, hundreds of new examiners of new stuff to make sure they can comply with the deadlines. But I mean, the negative part of this is, you know, there are many newbies, newcomers in the trademark officer, so the quality of decision, you know, has been varying a lot recently after the new trademark law came into force. But still, I mean, they're taking those time frames very seriously, so this is the positive aspect. So if you're planning to register a trademark here in China, I think you can take benefits of the new trademark law.
Yeah, I remember the times when you were waiting for the registration like 4 or 5 years. So
right.
Hopefully
yes,
it's gone.
Yeah. So maybe just some words to administrative enforcement in case, you know, you have an infringement case. So maybe you have a Chinese company which is infringing your trademark. So in those cases, Chinese authority, they might impose a fine to the Chinese infringer, right, to the copy pirate. And for the first time now in the trademark law, they provide for guidance, you know, how high could be the fines are, you know. So example, it says if the illegal revenue of the infringer is higher than 50,000 RMB, then the administrative authorities could impose fines up to 5 times of the illegal revenue the infringer gained. Yeah, but this is just the administrative enforcement. But of course, you as a company might also decide to sue the infringer and in front of a civil court here in China and to claim for compensation payments, right? And now the new law also provides for detailed guidance. How is your compensation calculated? As you can see from this side, basically there are three methods to calculate the compensation. First is the actual losses you have. Second is the legal revenue of the infringer, or it might be a multiple of reasonable royalties, right? And if those methods don't work in practice, then look at the last bullet point, then the court could impose a compensation up to 3 million RMB, you know, and this is quite a major change in comparison to the previous law, because previously it was only 500,000 RMB. I mean, this is so low. If I would be an infringer, you know, I would laugh about it. 500,000 RMB, you know, I could pay this, you know, immediately out of my illegal revenues I get. But I think 3 million is not, it's not, you know, I think it's at least considerably higher, right? So I think also some positive changes in this respect. Finally, I would like to conclude my presentation with the last slide related to trademark law. I mean, there are some other changes. For example, the trademark law, now it's also possible for you to register sounds or jingles. And I think, which is pretty important, you can register a trademark not only in one class, but in several classes. I mean, of course, you would expect that. But now if you, oh, sorry, this is sort of my mobile, and I think it will stop very soon.
We are timing.
Yes.
Just
okay.
Time to leave
okay.
some
okay. No. So I just would like to conclude it. just conclude. So if you file a multi-class trademark application in the trademark office, okay, I think we cannot register your trademark for class 34 and class 42, but we are willing to register your trademark for other classes, then your application can still be upheld, for the other classes. So before, the whole application would have been rejected, but no, it's also possible to split your application, even if the trademark office is questioning, the application for some of the classes, you can still uphold your application for some other classes. So I think this is quite a benefit. And I think that's it about my presentation. I hope, there were some interesting facts for you. And
I really think so, because this legal update was perfectly timed and put together. We have received quite a few, I would say a lot of questions. I would divide them into two parts. First part is about company law, and the second part is about the labor questions. But I give Florian some time to read them, and in the meantime, I would just say that in addition to this webinar, the slides which will be later on available on the YouTube, so you can not download it, but you can see it online. EUSME Center has some publications related to labor law. It's about labor contract law, how the contract shall look like, and it has as well a publication on internal rules, which says about the staff handbook, about termination of the employees. And of course, I would like to remind our sister project, IPR SME Help Desk, who is the right person, right place to answer questions related to protection of the trademark or all the others. And of course, our today's guest, Mr. Florian Kessler. So now questions about, or the answers to questions about company amendment to company law.
Okay. So the first question would be, have the new changes of Chinese company law already implemented by local provinces, or will it take some time? So I can see that in major cities like Beijing and Shanghai, and even in the greater region of Beijing and Shanghai, the company law is already implemented. We already handled some cases where we could freely stipulate for our clients the terms and conditions and the articles of association. But I mean, the question is pretty much valid, because usually it takes some time, and some remote cities here in China, or third-tier cities, they might not be aware so much or used to foreign investment. So I think it takes some time for some cities to get acquainted with the new company law. But in those cases, you always have to discuss with the authorities in the provinces and maybe find a solution that is practicable. But it's completely right. I mean, it always takes some time until the new law moves into into Western and Central China, from the coastal areas. Yeah, that's right. So this would have been the first question. Now, the second question is, isn't it called subscribed capital instead of registered capital? This is an interesting question, because, in the past, officially, it has been called registered capital in the past, because the capital contribution had to be registered with the Chinese authorities. So the Chinese authorities would register, the amount of registered capital. It would also be stipulated in your business license. So this is why it had been called registered capital officially. But the question is interesting, because, it's exactly the point about the new company law. The amount of the registered capital will not appear in the business license anymore in the future. So it will not be registered with the Chinese authorities anymore. So now it could be called subscribed capital, because from now on you could call it's a system of subscribed capital and not registered capital anymore. So in your business license in the future, you will not find the amount of registered capital anymore like it has been the case in the past. So now you just have to subscribe it and to prove some evidence that you injected your capital. But officially no one can see anymore how much capital you injected in your company. So this is sort of the difference. So I'm very grateful for this question because I can further explain, the change from a system of registered capital now to a system of subscribed capital. So the last question, or there's another question for company law. The question is, what's the procedure to increase capital at a later stage for a wholly foreign-owned enterprise? So, I think this somewhat is not so critically anymore, because in the past it was like this, maybe because you had to register your capital and you had to inject your capital, your registered capital within a tight time frame. You had really, it made some headache to some companies because they don't want to set the registered capital too high because they don't need so much liquidity in the beginning. So I think we wouldn't have this sort of headache anymore in the future, because even if you stipulate maybe an amount of 2 million euro as a subscribed capital, now I'm calling it subscribed capital, then you can determine by yourself, or freely determine by, according to your needs, the time frame within you would like to inject this capital. For example, you could say, if you have 2 million euros of subscribed capital, you could say, I will inject it within 5 years, or 10 years whatsoever. So I think this is not a major problem anymore. But still, maybe if you think it's too low at the beginning, you still can apply to change it at the Chinese authorities. That needs approval from the Chinese authorities. If you want to change the amount of subscribed capital in the future, then you have to ask the Chinese authority for approval, and this could take maybe up to 1 or 3 months.
Yeah. And we have unfortunately only time for one question from the labor law, and all the rest which we have received will be answered later on via email. So those who send a question to us, don't worry, you will receive a reply via email. And the question about the labor law is related to the representative office and hiring staff through the FESCO. I guess it's probably hiring local staff. Yeah.
Yeah. One person is asking, I'm interested in knowing about a rep office hiring staff through FESCO-like organization. And thank you for your intervention. In China, it's only possible to hire local Chinese staff through FESCO. So in a rep office, foreigners are not allowed to be hired by a labor agency like FESCO. So you have to practically employ them abroad and then dispatch them to China. So I think, but there are not many restrictions about Chinese local staff hired by rep office, but still it's not a very smart construction, structure, because you are not the direct employer of the employee. So the labor agency will be direct employer, and you are, how to say, you are receiving the work as from the labor agency. So it's a quite weird construction, and it causes many headache in practice. And then, I think just move to the second part of the question. Is there any possibility to set up a WUFI by an NGO? So in practice, this is a very, very complex process, because Chinese authorities, they very closely monitor, as you can assume, foreign NGOs. So to set up an NGO here it's possible, but it requires a lot of lead time, and it's a lot of work. So it's more complicated to create an NGO. So maybe the NGO might think about to set up a WUFI or rep office here in China. So this is practically possible.
I agree with you, Florian. It's quite a complex question. And just to keep in mind that the WUFI is meant to be like profit-making organization, which normally NGOs are not. So I suggest the lady who asked the question to connect with us, and we can discuss a little bit later about
Sorry, I think this is a very
options.
This is a very complex question, so I cannot explain it here.
In a few seconds. Okay, Florian, thank you very much for coming here and giving us very broad and informative presentation of the updates on the laws. And I hope it's not the last time you come here. And thanks as well to our participants. And I hope that you will connect with us in some future webinars.
Okay, thank you also from my side, and wish you a nice week.
Yeah, goodbye.